Hi, I'm David Gans, the Civil Rights Director at the Constitutional Accountability Center. This morning, the Supreme Court heard one of the most important abortion cases it's heard in the last decades. The right to abortion is deeply rooted in the 14th Amendment's text and history. It's a fundamental right that flows from the Constitution's protections of bodily integrity and the right to establish a family and decide whether and when to bear and raise children. These fundamental rights, long denied to enslaved persons, were guaranteed by the 14th Amendment's guarantees of liberty, equality, and equal citizenship stature. This morning, the Supreme Court heard an oral argument in Dobbs versus Jackson Medical Center, which concerns these very fundamental guarantees of the 14th Amendment. It concerns the validity of Mississippi's ban on abortion after 15 weeks, and more fundamentally, whether the court will continue to respect the 14th Amendment's promises of liberty and equal citizenship. Under the Supreme Court's precedents, Dobbs is an easy case. Mississippi's laws ban abortions before viability, and it's flagrantly unconstitutional. During much of this morning's arguments, rather than grappling with the text and history and the court's long-standing precedents protecting fundamental rights to bodily integrity and to family decision-making, we saw the court's conservative justices looking for ways to justify removing constitutional protection for the right to abortion. And I want to kind of run through some of the different arguments we saw being made in their questioning by some of the conservative justices on the court. Brett Kavanaugh asked, why should the court be arbiter of abortion cases at all, such as this one? And he suggested the court should be studiously neutral between the rights of the individual and state power, in this case, state power to prohibit abortion entirely. Justice Amy Coney Barrett, on a number of occasions, pointed to safe haven laws that permit an individual to surrender a child and terminate their parental rights. That, she suggested, obviated the need to protect access to abortion care as a fundamental right, seemingly dismissing the fact that the right to abortion is a matter of bodily integrity as well. Justice Alito questioned whether abortion could be a fundamental right if states prohibited in 1868, and Chief Justice Roberts repeatedly raised the possibility of changing the viability rule to accommodate laws like Mississippi. And what's really striking is that none of these justices grappled at all with text, history, and structure of the 14th Amendment and the longstanding precedents that safeguard bodily integrity and free choice in family affairs. They simply really didn't grapple with the kind of fundamental constitutional questions that are at the heart of the case. And I think it's really important to sort of focus on this framing that Justice Kavanaugh introduced. And I think that it's critical to take away that the Constitution is decidedly not neutral when it comes to protecting fundamental rights, including bodily autonomy and reproductive liberty. The Constitution safeguards these rights and commits the courts to protecting them from state infringement. And that reflects the legacy of slavery. We had, hundreds of years in which individuals had no bodily integrity at all. They were held as slaves. They had no control over their bodies. Women were forced to bear children, to propagate the institution of slavery. And the 14th Amendment is a response to that, and it mandates, as a matter of liberty, as a matter of equality, as a matter of equal citizenship status, that these rights are fundamental and belong to the individual. And it's crucial that the Constitution is not neutral about that. It commits protection of those rights as a fundamental, deeply rooted matter. And so, Kavanaugh sort of says, well, we're just going to try and be neutral between the individual and the state. The 14th Amendment is not neutral between the individual and the state. It demands protection of the individual's rights in controlling their body and their lives and their dignity. And whatever the interest in protecting potential life, it can't extinguish the rights of a person who's already been born and is entitled to their full constitutional rights, including their right to be an equal citizen entitled to control their own body. And again, if you look at the other side, there are some who've argued that the fetus should be considered a constitutional person, which would prohibit any laws that allowed abortion and allowed access to abortion care. Some have argued that's how the court should decide this case. And it's notable, Mississippi didn't say the fetus is a person. So if you look at Kavanaugh's equation, you have sort of on the one side the adult individual's right in controlling their body, and on the other you have a state interest. But the court has never said that the fetus is deserving of constitutional protection of the same court. So the neutrality framework, I think, really falters for that reason. Second, one of the arguments that you hear over and over in some of the court's major fundamental rights cases is this idea, well, we're going to go back to 1868 and look at state practice. And that was the argument Justice Alito made. He said, the touchstone should be state practice in 1868. And how can the right to abortion be a fundamental right? Lots of states had prohibited it earlier at the founding and through much of the 19th century. There were many states that allowed abortion, even at the time that Mississippi is seeking to ban. And there were some states at the time of the 14th Amendment that had, for discriminatory reasons, instituted abortion bans. And Alito says, well, because of those bans, it can't possibly be a fundamental right. But again, if that were the methodology, states would still be able to prohibit interracial marriage. Alito's theory conflicts with scores of Supreme Court cases protecting fundamental rights, including Loving versus Virginia, which was a case where the court held that the right to marry an individual of another race is a fundamental right, notwithstanding the long history of miscegenation laws in this country at the time of the 14th Amendment and well before. And so to adopt 1868 as the touchstone for fundamental rights is to say that many of our most cherished fundamental rights are not rights at all. And Justice Sotomayor made this exact point during the argument, suggesting that if the court accepts Mississippi's argument to overrule Roe, Obergefell might be next on the chopping block. And she commented that the Mississippi Solicitor General's argument that all those other precedents were safe was dissimulating. And if you see, once you sort of accept the idea that we're going to look to history to cut back on the protection of fundamental rights, there's a long line of precedents from Loving, some of the court's cases protecting access to contraceptives, protecting the right to marry, including Obergefell, that would be in tension with those rulings. What happens in Dobbs will determine the legacy of the Roberts Court. We'll have to wait in June for a final ruling, but what we saw today is a disappointing pattern of conservative blindness to the 14th Amendment's text, history, and bedrock protections for fundamental rights and equal citizenship. And this is a pattern that I think we've seen a number of times with the Roberts Court of selective originalism, so where they're willing to look at some parts of the Constitution, but when it comes to the 14th Amendment, to parts of the Reconstruction Amendments that transformed our Constitution and made equal citizenship, equality, fundamental protections for liberty a core part of our structure, they turn a blind eye to those. And I think that's something that we saw this morning in this morning's argument. To read our full brief in this case, which really details the text and history that supports the right to abortion as an originalist principle, check out our website at theusconstitution.org.